You have an opportunity at this stage to fly right and get this figured out. I hope you take that opportunity. So, Mr. AG, come on forward.
Oh, Jill.
Yeah, do you need something from? Oh,
So your arm again forward. The pretrial offers, the statements of defendant on plea on all the cases that we're pleading to, 2 cases are being, cause numbers being dismissed pursuant to the offer. Just make sure I got everything. So this is all the legal work, all of change of lead forms along with the JNS on.
do we need a post conviction?
I think you're asking for that.
I'll be looking forward to going through it.
And then there's the 2 cause numbers that are getting dismissed pursuant to the global offer that the city handed up the dismissal orders on.
Can you?
Contemplating the best way to do all this, so. give me just a
Understood,
second.
Having that matches the current MCF, it's just gonna mirror what's in place. That's the only difference.
So Mr. AG, what I think we're gonna do is I'm gonna take you through your rights forms, if you're okay with it, as a group. We're then gonna enter the pleas one by one based on the charge. And if that gets confusing, we'll try to do, we can do them each individually, but we're gonna try to do it this way first, and hopefully it works for us. So you are Caden Thomas AG, you are 22 and you've completed 12 grades of school, is that correct?
That is correct, Your Honor.
Are you able to read and understand the English language?
Yes, Your Honor.
Okay. In entering pleas today on 2 protection orders, cause number 5A03378855, 1 count of cyber harassment, cause number 5A02224440, 1 count of reckless driving, cause number 5A02222448, and 1 count of protection order violation at cause number 5A03378856. You are giving up important rights today. The rights are the same on every one of your cases. We're going to review them as a group. On all of the charges that I've just listed, you have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. On each charge, you have the right to remain silent before and during trial, and the right to refuse to testify against yourself. On each charge, you have the right at trial to hear and question the witnesses who testify against you. On each charge, you have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. On each charge, you are presumed innocent unless the charges are proven beyond a reasonable doubt or you enter a plea of guilty. And on each charge, you have the right to appeal a finding of guilt after trial. On all of the charges that we've talked about, do you understand those rights, Mr. Agee?
I do, Your Honor.
Do you understand that in pleading guilty today, on all the charges that we have talked about, that you are giving up those rights associated with trial?
Yes, Your Honor.
The 2 counts of protection order violation are both gross misdemeanors, each subject to 364 days in jail and a $5,000 fine. The reckless driving case is also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. The cyberstalking case is a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. And the other protection order violation is also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. On all of these cause numbers, I've been handed pretrial agreements. 2 pages of pretrial agreements here. You understand the court is not obligated to follow anyone's pretrial agreement, but can sentence you on each one of these cases up to the maximum, which in all of your cases is 364 days in jail and a $5,000 fine. Do you understand that?
Yes, Your Honor.
Yeah.
The court can place you on probation for a time frame on these cases. On some of the cases, the time frame is 2 years. It's on your reckless driving case, your cyberstalking case. On other cases, the probation time frame is 5 years. Those are your protection order violation cases. During those probation time frames, either 2 years or 5 years, the court can impose cost, fees, and assessments during those time frames. Do you understand that?
Yes, Your Honor.
On one of your cause numbers, which is your reckless driving charge, there is a mandatory 30-day license suspension. Do you understand that that is not something that the court can waive or prevent, but is something that is required by statute?
Yes, Your Honor.
I'm going to mark box J. It has been marked out.
Is that the,
Mandatory license suspension for the 30 days.
yes, Your Honor, that's fine.
So Mr.
You've
A-
already served the 90 days on the rest.
So Mr. AG, I'm just simply, that mark box was marked out. I'm just adding that back in. Do you understand?
I understand.
Okay.
And I would note for the court that I did go through the DUI sentencing curriculum.
I did see that attached. We also have special provisions on the protection order cases in regards to a mandatory $15 fee for each violation of a domestic violence protection order. We also have, you are giving up your right to own or possess firearms on each one of the protection order cases. Do you understand that those are mandatory conditions, again, that are required based on the plea?
Yes, Your Honor.
That is also a requirement on the cyberstalking charge. Okay. All right, we're going to go a little bit more individualized now because I think we're through all of the required provisions. So the first case that we're going to do the individual factual basis on is cause number 5A 0337855. These are 2 violation of protection orders, domestic violence. To the charge of violation of domestic violence protection order on taking place March 7th, 2025 in the city of Battleground, Washington. Again, 2 counts. How do you plead?
Guilty.
Guilty to both charges?
Yes, sir.
Are you making the plea freely and voluntarily?
Yeah.
Has anyone made any threats or promises to you on these 2 charges to get you to enter a plea?
No, Your Honor.
The factual basis states on March 7th, 2025 in Battleground, Washington, I did knowingly violate the
Restraint provision.
restraint provision of a protection order of which I had knowledge by attempting to call the protected party twice. Are those correct statements?
Yes, Your Honor.
And that person was Autumn Rose Barnett. I'm going to find you're making a knowing, intelligent, and voluntary plea to those 2 charges after advice of rights and advice of counsel. Then I'm going to go to the next group of charges. This is the cyberstalking charge. cause number 5A02222440. This charge, domestic violence, this charge states that on February 17th, 2025 in Battleground, Washington. Sorry. To the charge of cyberstalking domestic violence taking place February 17th, 2025 in the city of Battleground, Washington, how do you plead?
Guilty.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
Has anyone made any threats or promises to get you to plead guilty?
No, Your Honor.
February 17th, it says factual basis says on February 17th, 2025 in Battleground, Washington, I did with intent to harm or harass, make anonymous repeated electronic communication not constituting telephone harassment. Is that a correct statement?
Yes, Your Honor.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. To the plea.
It should be cyber harass.
Cyber harassment.
Okay.
Cyber harassment, I apologize. On cause number 5A02222448, this is an amended charge of reckless driving. To that charge taking place on February 26th, 2025 in the city of Battleground, Washington, how do you plead?
Guilty.
Are you entering this plea freely and voluntarily?
Yes, Your Honor.
Has anyone made any threats or promises to you on this case to get you to plead guilty?
No, Your Honor.
Factual basis states on February 26th, 2025 in Battleground, Washington, I did operate a motor vehicle with a wanton disregard for property. Is that a correct statement?
Yes, Your Honor.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Moving on to the final protection order case. This is cause number 5A03378856. This is another protection order violation. To the charge of protection order violation, domestic violence. This is taking place on March 10th, 2025 in the city of Battleground, Washington. How do you plead?
Guilty.
Are you entering this plea freely and voluntarily?
Yes, Your Honor.
Has anyone made any threats or promises to you to plead guilty on this charge?
No, Your Honor.
Factual basis states on March 10th, 2025 in Battleground, Washington, I did knowingly violate the restraint provisions of a protection order for which I had knowledge by attempting to call the protected party. Is that a correct statement?
Yeah.
Accept the plea on that charge, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Okay. Based on those pleas, we're going to be dismissing cause number 5A03000095, and I'm signing off on that dismissal. We are also dismissing cause number 5A04212215, and I'm signing off on that dismissal. Give me just a minute before we start talking sentencing. I just want to get everything where it needs to go real quick here.
I have a couple more forms.
We have a lot of forms, but yes, I'm sure we do. Give me just a second to
Yeah.
get everything from the pleas put away here real quick. Okay. Ms. Carmi, did you want to do those forms before sentencing?
It's up to you. I can talk about them and hand them up as sentencing discussion.
What do we have?
One is, part of the BTA is a post-conviction NCO on 440, the cyber harassment case. And I believe that is part of the bargain here. Also on 440, because it's a harassment case, there's mandatory DNA collection that I'll hand up. And then, on the two DV NCO cases ending in 855, 856, and the cyber harassment ending in 440, I've done one notice of ineligibility to possess a firearm.
Mr. Cheney, were you able to discuss with Mr. AG all of these various forms? that
Yeah,
are being handed?
no objection. We knew there was a no contact order, so that's no objection on that. No objection. Also, he's willing to sign the declaration of non-surrender. He understands that. I'm not sure that the cyber harassment, as opposed to the harassment statute, actually requires the DNA sample. But rather than litigate that issue out, he's willing to have the DNA sample.
Mr. AG, what I will tell you is that the no contact order that's being entered long-term here, is a complex legal document. You certainly have had issues with this before. It seems to me that things have stabilized quite a bit since the March timeframe in your case. The only hope is that you read through this document, you understand the provisions of the document, and that if you are unsure if your conduct would potentially violate the document, probably best not to act. Okay. I'm going to put these all in the respective files. Mr. Cheney, I'm going to go to you if you want to start regarding sentencing.
Sure, Your Honor. So we would generally ask the court to follow the pretrial recommendation. As the court may recall, he did 13 days in custody in the early March timeframe. Candidly, I'm not sure if they were on the earlier cause numbers or the new cause numbers, but regardless, he's got 13 days credit time served. We would just ask the court to allocate that to any of the VPO cause numbers effectively. And then he's willing to serve the remainder on the work crew. I think the key thing is the court is fairly familiar with Mr. Aggie at this point, is that I think he's been working on his sobriety quite a bit. And I think that's the number one thing that is, as the court noted, a significant turnaround from February and March to now is, quite frankly, the sobriety aspect of this. And I think that's a very positive sign. Of course, he knows that if the sobriety goes sideways and there's new sideways movement, there's a lot of suspended time hanging over his head. And he understands that. He's very remorseful about this. We've talked quite a bit over the last few months about making sure that, again, the sobriety aspect of this going forward is going to be the critical element, in my perspective, for how we stay out of getting that probation time imposed for potential or new charges potentially here. I think that he's had a real wake-up call about this issue, about when a judge tells you not to have contact, that's exactly what it means. Don't have contact. And when that happens repetitively, there are severe consequences as a result that can arise. And he understands that. I think, like I said, this has been a real wake-up call for him. He's fairly young, but that's not to say he can't, by maintaining sobriety, put this behind him. We would ask the court to consider the Bozina waiver. Funds are very tight. He's having a very hard time getting housing right now because of the nature of these charges. He's gotten denied housing now several times. And so that is going to take quite a bit of work. I would assume that the same problem may arise within the employment context as in the housing context as well. But certainly having these cases resolved and having some of the charges dismissed as a result of this plea will hopefully open up some avenues to get back to the workforce and get into stable housing.
And just to make sure I'm understanding perhaps the parties, I have on one of the PTAs a total of 15 days of work crew. I have another PTA a total of 15 days of work crew. Are these consecutive or concurrent between the two PTAs?
Our understanding was consecutive. Certainly, if
Okay.
it were to be concurrent, that would be appreciated, but our understanding was consecutive.
Yeah, it was just that given the number of charges, we had to spread it out
I
over
understand.
two. So the expectation is 30 total
30 with 13 days.
with
so
13.
balance
And
of 17 days.
Yeah, and 13 was technically done under the 855 cause number. However, the court wants to apportion it. It doesn't really matter to the city.
Yeah, we'll defer to the court on that issue, however the court wants to divvy that up.
Mr. AG, is there anything you'd like me to know?
I have signed myself up for AA classes just to get ahead of the ball game. That's about it.
Well, there was a period of time where the conduct and the continued conduct from you is very concerning. You have demonstrated to the court, based on your conduct really since the March timeframe when things went really poorly, that things can get better. You're a young person. These are going to be charges that are unfortunately going to be kind of heavy around your neck for a period of time. And the circumstance really at this stage is these are all, or for majority of these cases, can eventually be vacated if you don't continue to break the law. Once you get a new criminal charge, generally these are all going to be prevented from being removed from your record. So you have an opportunity at this stage to fly right and get this figured out. I hope you take that opportunity. I'm certainly going to be seeing you over a period of time to make sure that that happens. So let's move on to sentencing. On cause number 5A02222448. That is going to be 364 days in jail with 354 days suspended, leaving 10 days to serve. That's going to be jail for a period of 10 days with credit time served for 10 days. So you're not doing any more jail time. I'm just going to assign it on that case. It'll be a $5,000 fine with all 5,000 suspended. I am finding pursuant to Blazina analysis, you are indigent. Bench probation on this matter for 24 months. This is the driving case. So the conditions on these cases are all going to be very similar. They are to obtain a substance use disorder evaluation. That's not what AA is. It's actually more involved than that. On this matter, because it's the reckless driving charge, you will also be assigned victims impact panel. We're going to set the same review date on all of your cases. That's going to be on November 6th, 2025 at 1:30. On this case, I'll be looking at your substance use disorder evaluation, any recommended treatment that you're undertaking, and your victims panel. Next plea case is going to be 5A033785. These are the protection order cases. I'm going to strike that. I'm going to move on. I'm going to go to the other PTA. I apologize. 5A02222440. This is the cyber harassment charge. The cyber harassment charge is going to be 364 days in jail with 359 days suspended for a total of, 359 days suspended for a total of 5 days. 3 days of which will be jail with credit time served for 3 days. So that takes care of our 13 days credit. The remaining 2 days will be on work crew. When you finish court today, you're going to go to the same location where you checked in for court, ask to speak to the work crew chief, and he'll get you signed up.
Okay.
It'll be a $5,000 fine with all 5,000 suspended, sentence suspended for 60 months. I am going to waive all fines on this case. Bench probation for 60 months, conditions, no law violations. Again, this charge is going to have a substance use disorder evaluation, comply with any recommended treatment. We're going to use the same return date, which is November 6th, 2025 at 1:30. And again, on that date, I'll be looking at substance use disorder evaluation and any recommended treatment.
Cyberstalking or cyber harassment.
Okay, so there will also be a DNA assessment. I'm not seeing that on the plea form, but Madam Clerk, if you want to mark that for me, that's fine. I have signed off on the standalone document. I've already signed off on that too.
And then when he'll sign, like I said, that declaration of not surrender.
Okay, we're gonna move on to 5A0337-855. These are the two protection order violations. Be 364 days in jail with 359 days suspended on each count. So a total of 10 days on work crew on this matter. Both counts, $5,000 fine with all 5,000 suspended. Both counts, I am going to be assessing the domestic violence $15 fee. So it'd be a total cost of $30. Bench probation for 60 months. No law violations. Domestic violence evaluation in this matter. Comply with any recommended treatment. No consumption of alcohol, non-prescribed drugs or controlled substances during the term of this probation. We're going to set the same review hearing, sir, for November 6th, 2025 at 1:30. On this case, we're looking at the domestic violence evaluation, recommended treatment on that. Final case for sentencing is 5A0337-856. This is also the protection order violation. 364 days on this case with 359 days suspended. Leaving 5 days to serve on work crew. The work crew sanctions are all consecutive to one another, so we should have a total of 17 days of work crew. $5,000 fine with all 5,000 suspended under Blazina analysis, sentence suspended 60 months. I am going to impose the domestic violence DV conviction fee of the $15. Conditions, no law violations, bench probation for 60 months. This case will also have the domestic violence evaluation, recommended treatment condition. Same review date being set on this matter for November 6th, 2025, 1:30. So Mr. AG, when you finish court and get copies of all your documents, it will take several minutes. There's a lot of paperwork on this one. We're gonna get you some paperwork at the desk by the door. I then want you to go to the same location where you checked in for court, asked to speak to the work crew chief. He can get you signed up for the work crew. Do you have any questions, sir, regarding your sentences today?
No, everything's straightforward, Your Honor.
Thank you very much. Good luck, sir.
Thank you, Your Honor.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.